But to begin, could Vice President Harris follow Richard Nixon and challenge the filibuster? Yesterday, as you know, Chuck Schumer brought to the floor of the United States Senate this Freedom to Vote Act. The original legislation that would have protected our right to vote, the For the People Act, they couldn't get a single Republican to vote for it. Even though it passed the House of Representatives, not one single Republican would vote for it, and Mitch McConnell and other Republicans actively filibustered it. Now, had they not filibustered it, it would have passed because there were 51 votes, 50 Democratic senators plus the Vice President, Kamala Harris. But because a Republican said, I object, suddenly the bar went from 50 votes to 60 votes. And it failed. So Joe Manchin came out and he said to the Democrats, he said, I know how to work with these Republicans. They're not so terrible. They're not crazy. They're not obstructionists. They just have some specific objections to some things in your legislation. So let me work out a deal with them that is acceptable to them. So he got together with Lisa Murkowski, the independent who caucuses with the Republicans. She's from Alaska. She was a Republican. Her father was, a Republican. I think he was governor if he wasn't senator, one or the other. An old Alaskan political name. He got together with Lisa Murkowski and Amy Klobuchar, who is the principal author of this new bill called the Freedom to Vote Act, and came up with a piece of legislation that he and apparently several other Republicans, Manchin was kind of dangling it that, there'll be 10 Republican votes for this. Don't worry. There's some rational Republicans out there. He didn't name names, but he implying, you got Mitt Romney and you've got Lisa Murkowski and maybe Susan Collins. And I don't know, is there a fourth? But so anyhow, he wrote this bill on the premise that he could get Republican votes. And so Schumer yesterday said, okay, let's try this. And sure enough, 100% of the Republicans said, no, screw you. We don't believe in free and fair elections. And they used the filibuster to do it. Just to be clear, the filibuster, this thing where any individual senator can simply send an email or have their staff members send an email to the House Majority Leader or the Senate Majority Leader, in this case, that would be Chuck Schumer, and say, I object. And all of a sudden, instead of a majority, 50 votes plus one, being needed to pass a piece of legislation, it becomes 60 votes. This is not in the Constitution. It's not a part of any law. And it is damaging America. The founding generation was horrified by this. The original situation that set up the filibuster came about in 1808. But the filibuster itself really got fine-tuned in the mid-1830s when John C. Calhoun became the senator from, as I recall, South Carolina, and started giving speeches in which he called slavery a positive good. The House of Representatives had passed an actual rule saying that you may not mention slavery on the floor of the House, because this was as the abolition movement was really growing. Keep in mind, in 1830, England, or in the 1830s, England outlawed slavery, which produced this huge explosion of anti-slavery, abolition activity in the United States in the 1830s. And so the House outlawed it, which is why John Quincy Adams, after he left the White House, he was president, went back to being in the House of Representatives, ran for Congress from Massachusetts, and went back into the House just so every single day the House was in session, he could go to the floor of the House and say, I think slavery should be abolished. And they could say, you may not say that. And he'd sit back down. But in the Senate, what John C. Calhoun did is he fine-tuned the filibuster. And the filibuster was used 100% from 1836 until the end of the Civil War to block any discussion of slavery or abolition of slavery on the floor of the Senate. From 1865, or really from the failure of Reconstruction, 1876, until 1964, as historian Adam Gentleson notes, quote, For the 87 years between the end when Reconstruction ended until 1964, the only category of legislation against which the filibuster was deployed to actively stop bills in their tracks was civil rights legislation. And that, of course, is exactly what happened yesterday. The filibuster is just a rule that the Senate has that they can change anytime they want. And it's an unconstitutional rule because what it does is it gives more power to the votes of certain senators than other senators. Article 5 of the Constitution says, and I quote, "No state without its consent shall be deprived of its equal suffrage in the Senate." Now, suffrage is, your right to vote, your right to have your vote counted. This is the, what used to be referred to as the one man, one vote. And, a couple of decades ago, we changed it to one person, one vote. But I mean, you'll read the founders talking about one man, one vote, and this is the basic concept that no citizen's vote, no matter how rich they are, no matter how many friends they have, no matter how many Facebook likes they have, no citizen's vote counts more than any other citizen's vote. Well, the Constitution says that the same is true of the votes of the states. Each state has 2 senators. But with a filibuster, we have 41 states that represent 27% of America, 24% of America, of American citizens, who have the ability to block senators who represent 76% of Americans from having any say. And that's a clear and egregious loss of a state's equal suffrage guaranteed in the Constitution. So the filibuster is unconstitutional. So there's a history here, and it's a fascinating one. Back in 1957, Richard Nixon and Dwight Eisenhower had just won re-election in the election of 1956, November 56. They were sworn in on January 20th, 1957. And Nixon, Vice President Nixon, was presiding over the opening of the 85th session of Congress, the 85th Congress. And at that time, the filibuster rule, said if you want to make any changes to the filibuster, you have to do so with a majority, with a supermajority of votes. Not a simple majority, but you have to have 2/3 of the Senate, 66 votes. And Nixon, as vice president and as president of the Senate, issued what's called an advisory opinion saying this is against the Constitution. There are only 3 exceptions in the Constitution that say that you can have that you can require a supermajority. Impeachment takes 2/3 in the Senate to impeach somebody. Signing treaties, it takes 2/3 to sign a treaty with another country, and ratifying constitutional amendments. That's it. Those are the only things, the only places in the Constitution where it says the Senate must hit a 2/3 bar. Everything else is simple majority. So Nixon said the filibuster being a 2/3 bar is unconstitutional. And it stuck. He was quoted again in 1967 by Vice President Hubert Humphrey and again in 1975 by Vice President Nelson Rockefeller. And in 2013, when Harry Reid was facing obstruction in just getting cabinet secretaries and low-level judges through a Republican filibuster, he dusted off Richard Nixon's statement and said, okay, we can change the filibuster with a simple majority. We control 50 votes in the Senate. We're going to do it. And he did. And then in 2017, Mitch McConnell did the exact same thing, saying, okay, we're gonna drill a hole in the filibuster for Supreme Court justices so we can get Neil Gorsuch and Brett Kavanaugh on the court with fewer than 60 votes. Something that had never happened before. And he did. So here's the delicious irony. The Supreme Court, the filibuster has been used consistently over almost 200 years now to block civil rights legislation. That's been its principal cause. And wouldn't it be extraordinary if America's first black vice president, and America's first female vice president for that matter, was the one who punctured the filibuster? If Vice President Kamala Harris was to do what Richard Nixon did as president of the Senate, which she is, as he was in 57, and say, I do not believe that the filibuster is constitutional, and therefore it should be removed. Now, that would then provoke, it wouldn't end the filibuster, it would provoke a debate in the Senate about the future of the filibuster. But the debate would be completely different. It would be on different terms. It wouldn't be, do we do away with the filibuster or not? It would be, is the filibuster constitutional or not? And that could easily lead to all kinds of things happening, including holes being drilled in the filibuster.